Ladies and gentlemen, if you can take your seats, we'd like to get this session underway. And just a reminder, if you're looking for the pandemic breakout session, that is happening on the 9th floor in a room which shall not be named. There is a woman in there. All right, as everybody gets settled, I think I'm not remiss or overstepping in suggesting that we might get a little debate on stage. Certainly it's a lively subject, and we've got 3 people with us who know how to debate. And this one will be the subject of this panel, as you know, Ontario Auto Reforms, Oasis or Mirage, moderated by Randy Bundes, who is Vice President of Operations and General Counsel at IBC. And I'll hand it over to Randy to introduce our panelists. Randy?
As Amanda said, I'm the Vice President, Operations and General Counsel with Insurance Bureau of Canada, and I get the pleasure to moderate today's debate, Ontario Auto Reforms, Oasis or Mirage. Now, it's been only 3 weeks, exactly 3 weeks ago, and one day, Ontario's most recent version of auto insurance reform came into effect. Now, over the past 20 years, we have had many versions, each one of them promising to correct the deficiencies of the former, which had themselves proven to be unsustainable. Will this time be different? Is this reform an oasis or a mirage? Now, we're fortunate to have 2 prominent Ontario trial lawyers with us today to weigh into the debate. Will this time be different? From the side of the defense bar on my far right, we have Lee Samus, who's principal with Samus and Company. And representing the plaintiff's bar immediately beside me is John McLeish, senior partner with McLeish Orlando. Now, both of these gentlemen are well known and highly respected within the insurance industry. And you can find their biographies in the conference program. Now, we're going to begin the debate by giving both Lee and John 12 minutes, and I'm going to time them, for a formal presentation. And I'll get the big hook out when the time comes. And after that, I'm going to direct questions to them. And then toward the end of our allotted time, we'll open the floor up for further questions. So we'll begin with Lee's presentation.
Thank you very much, Randy. I have a PowerPoint here that I just want to run us through here quickly. I'm going to just very briefly talk about where we've come from with the auto insurance in Ontario, and I know that's painfully well known to some of the people in this room. And then I'm going to talk about where we are and where we're heading. I'm going to do this in a fairly abbreviated way, I hope. The first thing I want to say is the topic being named Oasis or Mirage is very suitable because we are in an inhospitable environment in auto insurance in Ontario. It's a nasty experience. We've encountered these alien creatures, the health providers, that we weren't accustomed to previously, and we're uncertain about what relief we are getting at any time. What's over the next dune, we don't know. And the environment is challenging viability. This is a very serious problem for most insurers that are doing business in Ontario. How's the product working out? Well, we all know that. It's not good. It has some real problems. We've lost perspective of our customers with this product. I might talk about that a little bit later on. We're fighting with our customers instead of serving them. We're running 2 sort of ungovernable systems at one time. That is a tort system where we try to manage legal liability using legal services, and then a sort of a healthcare-driven system we try to manage using healthcare professionals and assessments and so forth. These are 2 challenging environments layered on top of each other, which just makes things worse. We have a changing environment. Things are changing all the time, whether it's by reforms such as the ones that have come in a few weeks ago, or whether it's as a result of some case law or some development of that nature. Things are changing all the time, but the system has lead feet when it comes to responding to those changes. And finally, we've created a system that is so complex that it's driving the public away. When I heard that the Quebec auto policy wasn't understood by their customers, I thought it's nothing compared to what's going on in Ontario. Our customers don't understand our policies. I will not ask if the people in this room understand our policies. The hard numbers. Okay. The claims environment, well, it's changed a lot since 1996. We've had a lot of ups and downs, but we've been using basically the same product based on the Bill 59 reforms in 1996. We've had ups and downs in that interval, and we have seen sort of flip-flopping back and forth between whether the tort was our problem or the SABs were our problem and so forth. But I suggest that what we should be doing when we're looking at Ontario auto injury coverage is we should be looking at them combined, because these are interactive. When we have more tort, we may have less no-fault. When we have more no-fault playing into the system, it may have an impact on the tort. You can't look at them independently. You have to sort of try to understand how they're operating as a package. And so I've found out that since 1996, I've been able to look at numbers that will isolate the costs for Ontario auto injury coverage aside from physical damage and direct comp. And so I've looked at those numbers so that we can have an understanding of how this product has performed since 1996. And there it is. 1996 onwards, loss ratio 93.4%. The last decade, 95.7%. Now, I understand that people in this room would like to see those numbers about 20 points lower, so that these are not good numbers. But on top of that, these are numbers over 15 years. There are good years in there, not all bad years. If this is the long-term outcome for the biggest part of the biggest product in the biggest market, people in this room should be very concerned. This is not a satisfactory cornerstone for your business. So what has this meant for consumers? Well, their premiums in this interval has gone up 54.7%. And I've just listed a couple of factors here to explain why that premium might not have gone up at all. It might have even gone down. But the fact is, it's going up. So not only are insurers taking a bath here, but the customers are taking a bath here on the cost. And that led me to the next question. I said, well, okay, insurers are losing their shirts on this product, and customers are paying through the nose for this product. What are they getting out of it in terms of benefit? And I took a look at that, and I said, well, what's happening in terms of impairments? And I looked at disability-based payments on the theory that we're only paying people who have disability payments, which may not be true. But the average cost per disability claim has gone up 216% during that interval. The customers are spending more, we're taking a bath, and nobody's getting better, they're getting worse. This is 3 strikes and you're out on the current system. So, where are we now? Where does this bring us to? Well, here's the key concepts that drive the problems that we have today. This is what is in our auto insurance system, in my view, that drives the difficulties that we have. Healthcare gatekeepers, we went into a no-fault system in 1990, naively relying on the healthcare keepers to regulate themselves, only prescribe what was necessary. We look so Pollyannish in the background of that, it's unbelievable. Use of medical models of entitlement definition. We switched from a tort-based system to start talking about impairment and treatment and rehabilitation and wellness and so forth, something that we didn't know anything about, and we embraced it in a big time. Segregation of claims by severity. This is a huge issue. Don't lose track of this going forward. When we start saying, well, it's important to know who's got a minor injury or who's got a CAT injury or who's in the middle or on the tort side, who's above threshold and who's below threshold, we're doing all this stratification of claims by impairment. And this stratification costs money. You need to investigate, you need to do assessments, you have friction costs with litigation and so forth to figure out who's where in those stratifications. There's a reason that we have those stratifications, but they're costly. And to have so many of them embedded into our system, we've got all these different categories that we have to look at each claimant for. Somebody has to open a file, administer, and so forth. It's not good. We also have the principle brought to us by the NDP government in 1993 that we should attempt to cover all losses that might result from a car accident on a no-fault basis. I don't know what the policy validity is of that, but that's still hanging out there in the background. We pay things for our Ontario auto accident victims that are not paid under any other system in the world. We pay people to drive back and forth for medical treatment. We pay people for babysitters. We pay all sorts of stuff that you don't get in other kinds of systems. And then we have the imbalance in recognizing the interests of the insurers and the insureds in the system. It was a design feature that was introduced in January 1st, 1994. The government of the day made no bones about it. They were designing a system that at any point of decision it tilted in favor of the consumer, and certain people have taken advantage of that to maximize their gains from the system. And then we have a system that's designed with rigid procedures which are really constraining the ability of your claims folks to do what they need to do to get the right payment to the right people in the right time. And the final piece that's in this that causes some of the problems, maybe a lot of them, is we have a dispute resolution process that's in place here that sees itself as a regulator of your conduct, not as an impartial arbiter of entitlement under the legislation. So these things here are the gorilla in the room. When you look at the reforms under the auto insurance system, you will hear us talk today about minor injury and cat impairment and incurred expenses and these things. That's the ball being passed back and forth between the white-shirted people. This is the gorilla that we're not seeing. So what are the reforms that are being rolled out now to deal with the problems that we have now? Change in assessment costs. This is a big item. Assessment costs for consuming a lot of money. And I have to say, these reforms that are coming out now, I just want to make absolutely clear, are significant and positive. I have no doubt about that. But the question is, are they significant enough? Are they long-lasting? The assessment fee cap that's being brought in by the government, I have to tell you, could be a showstopper. If our claims folks cannot get the assessments they need with the cap that is now legislated, they will not be in a position to adequately respond to claims. And that imbalance in the system could be a big cost driver going forward. Watch out for that. Minor injury, very, very important concept. It's a stratification, it has friction costs, it has all of those things. We're trying to contain exposure for a large number of claims defined as minor injury under the regulation. Target, apparently, is to get 55% into that stream. That's a pretty high number. I don't want to be predicting too soon here about this, but it would be quite surprising to me if we ever made that number. Third feature of the reforms is reduction of benefits. Some of the, I'll call them fringe benefits, richer benefits are being taken out of the system, but the government didn't really take them completely out. They just made them harder to access to people. There are two ways for people to get to those benefits that have been taken out now. One is to buy optional benefits. Very interesting luncheon speaker yesterday about that. Very interesting challenges for intermediaries. See what people do or don't do about buying optional benefits. And the other approach to getting those benefits back that the government has taken away is to have the CAT status. That is, to be found under the regulation to have a catastrophic impairment. So here's the thing. Minor injury and CAT is everything about these changes. Minor injury, what is it? It's PAF-like. Do you not know what PAF is? PAF is a former program that's been in force since, 7 or 8 years, trying to isolate the less serious claims in the system and treat them in a more cost-effective way. It didn't play out. It was a disaster. It was expected to do very well. Its prognosis was much better than the current prognosis for minor injury, and it didn't do well. So the fact that the current concept seems like PAF is causing some problems. There's some issues about the drafting and the guidelines. There's a $3,500 cap that applies to everything that is predominantly a minor injury. And that's great. I like the predominantly language. I like some of the language in the regulation. I think there's going to be a lot of claims that shouldn't get $3,500 that are now going to get $3,500. And then I think we have to worry about the wiggle room for pre-existing conditions. There's provisions in the clause that say, well, even though there's that cap, if you have a pre-existing condition and put some stuff around that, then you can get past that. So there is an escape clause, and we don't know how open that escape clause is. Very important question. Psychological conditions which might provide easy avoidance of minor injury guidelines. Are psychological conditions going to say that those people are not covered by the minor injury guidelines? Because psychological conditions are popping up everywhere. Big question mark. Catastrophic impairment. This is the other piece that we have to see how this is going to play out to look at the future. The reductions I talked about are non-CAT. The current definition of catastrophic impairment is essentially unchanged. There are a couple of very minor changes, but it's essentially unchanged, and it has been decimated in litigation, in courts, and arbitration. So the CAT notion that's embedded in the current regulation is seriously broken and hasn't been fixed yet. And a major issue with CAT is psychological impairments and how you deal with psychological impairments in these cases. So that's where we've gotten to. Where are we going? Well, what's our typical post-reform experience in Ontario? Everybody knows this. You've got the scars. You've been through this. We have this initial optimism. Then we started getting a little bit antsy about how it's getting rolled out. And then we start to see the other stakeholders play their cards, and we get nervous about that because they've come up with things we haven't thought about. And then we get hit hard with some court decisions and arbitration decisions that open the pathway for abuses. And then we get cost pressure. And then we go back to government and say, let's fix this again. And then they fix some of it. And then we start all over again. And we've done that, and I've been here, and we've talked about it before. We go through this cycle again and again. I expect exactly the same cycle to follow this time. What will happen with minor injury? Here's where I start getting into projections, and this is a bit tricky. We're worried because of the PATH experience. If that was any kind of an indication, minor injury has a lot of challenges, but people were mindful of that when they designed it, so I think things might be better. The language, there's lots of people who say, I don't like that language. It's not 100% what I like, but I don't hear anybody saying it's zero. It's got some value. The escape clause, as I mentioned, is a bit of a risk. I did a survey of SABS adjusters. I know there are probably no SABS adjusters in this room, but I did a survey of SABS adjusters because they're the people who are handling these claims. And I did an online survey. I got 135 or something responses, which I thought was pretty good from that community. They say they're very busy, but they had time to do the survey, so I'm glad to have their input. What did they say? They thought that the minor injury guidelines included psychological, 58%. A few weeks ago, the Psychologists Association issued a 126-page paper saying, no, minor injury guidelines do not include psychological. This is a huge disconnect in the system. We are going into a new product not knowing whether the psychological is in or out of the minor injury concept. I don't know how anybody can price this. If you don't have an answer to that question, with the prominence of psychological impairments out there, there's a big issue here. SABS adjusters were asked, how hard do you think it is to get past the minor injury concept? I'm talking about the new concept, not the old one. Easily get past. 62% of the adjusters said you can easily get past the minor injury cap. You know what? Does it matter whether they're right or wrong? These are the people handling the file. If they believe it, that's what the outcome is going to be. So can I suggest to you this? Maybe you need to build up some backbone in the people that are handling these claims to say, hey, we want to make sure that we're not being tainted by history and we're having a look at the new things for the fresh start. Very important. So my conclusion on this is that the minor injury piece of the reform is pretty precarious. What will happen with CAT claims? Well, we know the current model is on its last legs, or worse. And if we're going to have a better model, we keep hearing this, we've heard we're going to have a new model of CAT, a new definition of CAT, a new something. We've been hearing this for, 3 or 4 years, which is, an instant in government reform timetables, but not so good for your business. We don't know what that model might be. I mean, this is something I've thought about, and I've talked to many experts on this topic and done some work on this area. It is not obvious what such a model could be that would avoid the problems that we've had in the past. The major problem is going to have, again, be dealing with psychological impairments. So that's another component that we have to watch out for here. Future of psychological claims. I've shown you how the two cornerstones in the reform, minor injury and CAT impairment, depend on being able to deal with psychological claims. In 2013, it's expected that a new DSM-5 is going to be published. This is the manual that sort of sets out, all the psychological, psychiatric conditions that are being sort of recognized by that community. It is that labeling that comes from that manual which will translate into the awards of damages and entitlement in a lot of processes, but including in the courts and arbitration processes that you're involved in. Look at these new concepts that they want to roll out in 2013. Complex post-traumatic stress disorder. The problem with that was the old post-traumatic stress disorder was too narrow. It only captured people who had real problems where, they had very violent things. Depressive personality disorder, they're not talking about your SABS adjusters, but they might be. Sluggish cognitive tempo disorder, no comment. Personal relational disorder, the person you have a relationship with, the relation is not so good anymore. And that's the thing. And this one, this is a post-traumatic embitterment disorder. A sense of injustice from the way you're dealt with by the system. Could this happen to somebody who has an insurance claim? We're going to have this concept of psychological claims layered onto the problems that we have already in our system. I think we've got some things to be concerned about. What do the users think about the future? I asked the question in the SAB survey. The number of people who thought the SABS was now right, 0. Nobody even filled in the wrong box by mistake. 45% think that the system still needs significant change. I had another box for minor change. I didn't bother with that. 30% thinks the system needs to be scrapped and rebuilt from the ground up. These are people talking about putting their jobs in jeopardy with that concept. They're saying, rebuild the system that I'm part of. They're rolling the dice. I took a little slice of this survey for the trainer group. These are the people who are involved in training your staff. So just the ones who did the training, because I figured they're probably the ones that know best what's in the MIG, what's in the CAT, what the problems are on the street. And I asked them what they thought of the system. 56% said scrap the system and start again. Now, is this a happy way to start a new system? So, I don't mean to sound pessimistic, but I'm pessimistic. Thank you very much.
Thank you, Lee. Thank you, Lee, and now John will make his presentation.
Wow, after a talk like that, first thing I want to do is get out of the insurance business. I'm a plaintiff's lawyer. My world is claims, or the way I see it, compensation to people that have been injured in accidents, including automobile accidents. I know that insurance companies need to make money to stay in business, but loss ratios and profits are just not part of my world, other than the fact that I'm a realist. I know to have a good, viable, vibrant system, the people sitting in this room, their companies need to make money. One of the problems that you have out there is the judicial system that we're in. Judges and arbitrators, to some extent, they hate laws that take away people's rights. and they see these laws as taking away people's rights. Judges see it as a sign of a sophisticated country where people do have rights to be compensated if they're unfairly dealt with. I mean, we look at Afghanistan and Iran. I mean, those aren't democratic societies. I mean, those people don't have rights if they suffer wrong, other than perhaps go and shoot somebody. So that's the environment that we are dealing with, where judges will interpret laws and rules and regulations in a way that people do not lose rights. So the question on everyone's mind and mine is, are the changes such that we do have it right this time, and will premiums stabilize? I'm aware that's got to happen. People who are deciding these cases aren't. The stability in premiums is so far away from the mind of a judge. It doesn't factor into their thinking. So Lee has talked about some of the changes in broad terms. I'm going to talk about them a little more specifically, and how I see them from a plaintiff's point of view. So let me talk firstly about a minor injury, and I heard what Lee said about it, and the hopes of the insurance company is who will fall into that category of minor injury and who will not. And for those that don't know, the only entitlement that a person has to no-fault benefits who suffered a minor injury is $3,500. So minor injury is defined in the guideline. And at first it might seem innocuous. It includes a sprain, strain, whiplash-associated disorder, minor stuff, contusion, abrasion, laceration, or subluxation, and any clinically associated disorder. But when you get into the specific definitions, listen to how it defines, for example, a strain. Strain means an injury to one or more muscles, including a partial but not a complete tear. Or strain means an injury to one or more tendons or ligaments, including a partial but not a complete tear. Well, I got news for you. That includes things like a torn ACL, anterior cruciate ligament. It includes things like a torn rotator cuff. In tort, those are anything but minor. In tort, an injury like that, if that occurred, say, to a construction worker who needed a stable knee, who needed a stable and strong shoulder, that guy meets the threshold. That guy could have economic losses in the hundreds of thousands of dollars. And yet he doesn't meet the definition of minor injury for accident benefits. That's fine. But if you can't meet the needs of a guy like that, what good is a system? I mean, a guy like that might need vocational training. He might be out of the system for years, trying to retrain. Now, if we have time, there are ways to deal with a fellow like that. It just might not be through med rehab and accident benefits. It's going to take a responsible insurer to handle someone like that, and that individual is going to have a viable tort case if he is stuck by the minor guideline. but as pessimistic as Lee is about the definition, I mean, you can see from what I've said, I mean, there is some at first blush and maybe in the long haul, some teeth in it. So, are there ways out of it? You can be sure that lawyers and others have already looked to see, okay, how can we escape it or beat it or get out of it? There is possibly a way. So an injured person's injury does not come within that guideline. If the injury is predominantly a minor one, but based on compelling evidence provided by his or her health practitioner has got a broad definition, doctor, physio, OT, the insured person has a pre-existing medical condition that will prevent the insured person from achieving maximum medical recovery from the minor injury if he or she only gets the $3,500. Well, what's pre-existing? Lee's talked about psychological. I mean, there might be some stuff in the person's clinical notes and records pre-accident that's evidence of a psychological vulnerability. Everyone in this room has some form of arthritis starting in the late 20s or early 30s. They may not be symptomatic, but it's there, and there may be a vulnerability. So, I mean, Lee referred to it as wiggle room. It's just a question of what the judiciary is going to do with pre-existing condition. Another change is med rehab. I'll just talk about that for a second. For non-CAT, it was $100,000. Now people say it's $50,000. $50,000 now includes assessment costs. So it in essence is less than $50,000 when you do include assessment costs. People can buy up, but history shows that the vast majority of people, they go in to see their broker or whatever, just give me the cheapest policy I can possibly get. So, I mean, that's fine. I mean, that's going to save insurer money for people that otherwise would be entitled to $100,000. You know, plus the cost of assessment, it's now less than half. But there are going to be a bunch of people caught by that. People who are seriously injured may or may not go CAT based on something, the 55% whole body impairment or whatever, and they're left in the lurch for a year or two or longer. Again, if that person has a viable tort case, I think there's ways for the injured person's lawyer to deal with that if there's a responsible torturer on the other side. If that person has no entitlement to a tort claim and doesn't go CAT, for example, the people with the ACLs or rotator cuffs, if they do get past the minor cap, and there's still not much hope for them if they're limited to the $50,000. Third thing I want to talk about is incurred expense. Incurred expense applies to attendant care, housekeeping, and caregiving. And in the new legislation, incurred expense is defined, and I'll give you some of the definition, and then I'll tell you what some of the thoughts that are out there as to how to deal with it. One of the reasons I think incurred expense came into play if a person needs attendant care, doesn't matter whether they're cat or not. Let's say they're cat, entitled to $5,000 a month or whatever. The person's spouse or parent or child or friend could be their attendant. They didn't have to leave a job. They could be a stay-at-home person, and that person could qualify for attendant care. So now, for a person to qualify for money for attendant care, caregiver, or housekeeping, the claimant will need to establish that the expense was incurred. So, what is an incurred expense? Number one, the injured person had to have received the good and service, be it attendant care or whatever. Fine, that's always been the case. The injured person has paid the expense, has promised to pay the expense, or is legally obligated to pay the expense. And thirdly, the person who provided the good or service did so in the course of employment, occupation, or profession. There's more than that. Like that's a person that's in the attendant care business. But here's the one where it's got everyone's attention. Sustained an economic loss as a result of providing the goods or services to the insured person or injured person. So what is an economic loss? Let's say the person would otherwise, under the old system, be entitled to attendant care of $5,000 a month. And they want a friend to be the attendant. That friend has to incur an economic loss. Does the economic loss have to be equal to the attendant care of $5,000 or close to it? Or can it be a $20 taxi ride to get from the friend's house to the injured person's house? I spent $20 today to get to my friend's house to provide attendant care. I incurred an expense. So the feeling out there is that the incurred expense just has to be something. It doesn't have to match the attendant care, housekeeping money that's being paid. And because this is such a dramatic provision, it just may be a way, of the judiciary and dealing with that, and really, in essence, going back to the way it was before this definition, before the reforms. The last thing I'm going to talk about in the reforms is the fact that assessments are limited to $2,000. Well, that's not plaintiff's assessments. Those are insurer assessments. So I don't know a neuropsychologist that's going to do an assessment for $2,000. The tab for that is usually $4,500, give or take. So the insurers are stuck with that. I am under the new reforms, but I can top that up. I, as a plaintiff's lawyer, can have a neuropsych assessment done and say, look, you can only get $2,000 under the new reforms, but hey, don't worry about it. If your bill's $4,500, I'll pay you the $4,500. So it'll be interesting. I know there's been lots of talk on the insurance side about parceling it out and doing it in stages and trying to work around it. I don't know if that's going to last, but that certainly does create an advantage to the plaintiffs. So where do I stand? Isn't it kind of ironic? Lee is pessimistic. I'm always optimistic. I do think with the minor injury guideline, I do think it does have some teeth to it. I am optimistic, and I'll be honest with you. I do hope it works, because I don't want to see systems like some of our provinces have, where there is no tort. Thank you.
Thank you very much, John and Lee. Now for the debate. There's a certain amount of agreement, it seems, that I detected that maybe we didn't. It could be better, I'll put it that way. And I'm going to ask you, what further reforms, if any, would you think might be needed to the system to make it work better or to overcome some of the problems you've identified? I'll start with you, Lee.
Okay. I think the first thing we have to do is come to the conclusion that what we've got now is not what we want, and more importantly, it's not what our customers want, and not what our customers would ever pay the premium for that we're charging them if they knew what they were getting out of it. And so the starting point about reforms is to put the old one behind us and not use that as the basis or the paradigm to move forward with more adjustments to the old system. So my view, I'm with the 56% of the trainers who said, rebuild. Collapse the existing system, start afresh, look at new concepts. I don't see any tweaking. I mean, the reforms that are coming in are going to save the industry money. If the bleeding continues, it's not going to be as bad as it would have been otherwise. But the long-term prognosis is not good.
John.
The changes I would like to see are in tort. I think a verbal threshold is crazy. It's expensive. They just erode with time. I mean, a simple, easy way to do it, if you want to save money, to me, and I mean, I know we've had this debate, is with deductibles. If deductibles aren't working, and juries don't know about deductibles, I think you'd reduce a lot of transaction costs in tort. So that's one reform I think that could be put out there, is just eliminating a verbal threshold in tort.
Thank you. John, you identified a problem within the judicial system. Maybe problem is a wrong word, but a propensity of the decision makers, the arbitrators, the judges to interpret laws in a way that minimizes the way they take away people's rights. Now, with that in mind, what do you see that insurers and their lawyers might do going forward to help stabilize the current system, knowing that that is the judicial predisposition?
Ooh, that's a tough one. I've mentioned verbal thresholds already, because that's through decisions just eroded down to nothing, and I thank Aviva for that. They were the ones that took runs at that in the early days, and every decision it just seemed to just erode it further. I don't know where the problems do arise if they're on the AB side. I mean, if you get into catastrophic impairment situation or designation, I mean, the benefits are rich. I mean, I do think we have the richest benefit system in the world, accident benefit system. To me, if it's gotta be overhauled the way Lee said, I would say less accident benefits and higher tort limits, which would take care of those that are seriously injured. I mean, I was practicing law before June 22nd, 1990, when OMPP first came in, and Remember, in those days, med rehab was $25,000. Well, no one seemed to have a problem with it. And I know the theory with the changes, no MPP, was, deliver money faster to those that need it, regardless of fault, get them better, get them back working. That hasn't worked.
Okay. Any observations on that, Lee, or your own observations?
Well, I think that John makes a perceptive observation that insurers decide to take on the challenges of getting clarity from the court system about the threshold or any other issue, and they may get that clarity in an unfavorable decision, but I think it's important for insurers to have that understanding. Even if it's bad news, they need to know. And so I don't think you can wander around with a whole lot of fuzziness around these very important concepts, although we do, and we're going to have some more. To the extent that Aviva or anybody else decides to test some threshold or any other interpretation in the court system, I think the outcome adds value to the system by creating some certainty.
Okay. I'm going to shift gears a bit and now talk a bit about the stakeholders in the system. Healthcare providers, lawyers, others. A lot of people make money out of the system. I'll put the question first to Lee. And what role do you believe that stakeholders, such as trial lawyers and the healthcare providers, what role should they have to help maintain stability of an auto insurance system?
Well, the trial lawyers, the lawyers who are representing the injured victims, their duty is clear. They have to do their thing for their client. And they have to maximize their client's access to whatever entitlement that they have. And I don't think we should say to them, well, you have some other duty in another direction. I am concerned about things like contingency fees and so forth, which cause the lawyer to have a financial interest in the outcome, which I know there are good policy reasons why to have it, but that bothers me. I think lawyers on contingency fees may lose some objectivity or worse in a limited number of cases. So I don't think the plaintiff's lawyers have a lot of responsibility in that direction towards the stability of the system. They have an interest in it, as John has identified. They want the system to be healthy, but that's not their duty. With the health providers, I see this as a different problem entirely. I think it's a mistake on the part of a compensation system to look at health providers as gatekeepers for access to entitlement. The health providers have their training and duties are to their patients. They are advocates for their patients. They accept what patients tell them as relevant history is to be true. I think the problem with the health providers that we have is there's been some questionable behavior by a group of them, some very mercenary behavior by a fairly large group of them, and there hasn't been much constraint in by their regulatory colleges. Health providers need to think about what the last 20 years says about self-regulation of health professions, because that self-regulation doesn't seem to perform very well in this environment. So I think the regulators of health professions have a role to play that they're not playing.
John.
I'll just comment briefly, just with respect to contingent fees. I don't know that I have a client who could pay me by the hour. I mean, when they come into my and me bill them monthly or quarterly, when they come into my office, generally speaking, their lives are turned upside down. I mean, can I add to that by saying, oh, by the way, here's my hourly rate, and I want you to pay me monthly? I mean, they refer to contingent fees as the poor man's key to the courthouse. Well, it's like they're way beyond that in this environment. I mean, it's only the very rich or corporations really can afford to pay lawyers by the hour and finance cases. I mean, probably the average disbursements on one of my files, I mean, they're larger files than most. 100,000 with lots being way more. I mean, who can afford that if they've got someone in their family that's badly injured? So that's my feeling on that. with the healthcare providers, with in June 22nd, 1990, with OMPP and Med Rehab going to 500,000, and attendant care going also to 500,000, a growth industry was started. I mean, up till then it was 25,000. There's so many people with such a vested stake in things. I mean, how do you undo it? They are, you know, they're organized. They have a strong vested interest, and you know, they see their living being taken away. So they are going to lobby like they did hard and continue to do so.
Okay. Though, John, your practice is the more seriously injured victims, there are less seriously injured victims, and we know of the type of plaintiff lawyer that specializes in that area of practice. Do you believe that having a different recovery method for their practice may have an impact on the overall stability at that lower end?
Don't get me wrong. I mean, I cut my teeth in the early days on sore necks and sore backs, and then it just kind of went from there. I mean, the intention of thresholds in tort and minor guidelines in ABs is to get those kinds of cases out of the system, and for the sake of affordability and stabilization of premiums, they should be out of the system. They should be. So right now, I mean, those kinds of people that are injured do try and seek compensation. They go to a paralegal's office. They go to some lawyer's office. We get the calls. We don't take them, not because they're not injured, whatever. We limit the files we take, and we only take a certain number. So those people do have a legitimate injury that probably they shouldn't be compensated. But here's unfortunately what can happen sometimes, especially with ABs. A paralegal might say, look, there's this little thing in ABs called the cash out. And we can do that after 1 year. And the cash out will be higher if you've got lots of physio and lots of med rehab and a little bit of tenant care. So leave it with me. I'll organize that for you, and then hopefully a year or two from now it will cash out. Well, that's dishonest, and I don't know if the changes will catch that kind of thing. I hope they do. I don't know if they will.
Lee, what sort of advice would you give to insurers to counter that kind of conduct, to limit the negative impact from that behavior by plaintiffs' lawyers that play that game?
Well, I think the truth of the matter is that there's too much money changing hands. And when there's that much money changing hands, there's going to be a lot of people along the way, whether it starts with the tow truck driver, the body shop, the paralegal, the health providers, the lawyers. It just goes on and on and on. And so follow the money, and you will see the problems in this kind of case. So this is a system design issue. If we had a system that looked like a health care plan, where you got $500 for this and $350 for that, and that was it, none of this would be going on. But it's because of the richness and the open-endedness of the system that kind of behavior is facilitated. Now, could an insurer sit there and say, we will not lump sum settle any cases? Yeah. And would that change behavior? Yeah. But that would be costly for a number of years. And I don't see a lot of appetite with insurers to do this. We had this come up. This was a reform a few years ago, and the reform was put in that you could not settle a case. You could not have a lump sum settlement for 1 year. Prior to that, you could have one the day after the accident, and some insurers did it. And at the time we had that reform saying 1 year without a lump sum settlement was very interesting. Some insurers were saying, you can't do this is going to hurt us. And other insurers were going the other way, saying this should be longer or permanent or you could never have it. So I don't think there's any real good consensus about whether lump sum settlement of periodic payments is a good idea, but it removes that one incentive that John's referring to.
Good, thank you. Okay, I'm going to shift a little bit again. Back in March of 1980, auto insurance was made compulsory in Ontario. You had to buy it if you wanted to get your vehicle registered. I'd like your thoughts, the thoughts of both of you, on the impact you feel this may have had on the stability of the Ontario auto insurance system. You know, once it became compulsory, the government felt they had a role in regulating the devil out of it. So I'll start with you, Lee.
You know, it makes a lot of sense to say, well, we want everybody to have car insurance because they are going to cause accidents, they're going to be victims, and they should have some place to tap into. But we also have uninsured motorist coverage and motor vehicle accident claims fund, so that sort of reason for having that is pretty minimal these days, but we still have the notion that everybody has to have car insurance. I'd ask the people in this room to think about what that's done with their relationship with their clients. Are they able to sell car insurance to their customers? Because I don't think they have to anymore, so they've lost that skill set. They're not in touch with their customers. And as I mentioned earlier, I think a well-informed consumer would never pay what they're being asked to pay for automobile insurance. If they understood it, they don't understand it, they won't understand it. If they understood what it meant for benefits in the event of a claim, they just would not buy it. So this has hurt us because we've lost our sensitivity to what our customers want. I say I think of myself as part of this industry, I'm sorry. So our customers are not being served well. Secondly, when you think about it, what's really happened, look at this. 1980, they say, everybody, you have a car, you must buy insurance. You know, 1990, they say, we're going to set the rates for that insurance. 1990, they say, we're going to say what the benefits are, and we're going to tell how the insurance companies are, how they're going to deliver it, and in what timelines. You guys have become a government agency. The government has imposed a tax on motorists and said, you have to fund all this money into automobile insurers, and then they have to behave the way that we tell them. And are you surprised that you're not making money? That's what it's got us to.
John, any observations?
It is compulsory automobile insurance, and the product is offered by private companies. A big difference, I think, between Canada and the U.S. is our minimum limits. In the U.S., you know, there's some states that I don't know if the minimum limits are $15,000 or $25,000. Here, they're $200,000. I don't know when I last saw a case where the defendant only had $200,000. Maybe I've seen $500,000. Most of the time, it's $1 million, and if the defendant is underinsured with $200,000, usually the plaintiff usually has underinsured, say up to $1 million or more in some cases. So, I mean, thank goodness for that. I mean, I think that's a good thing, and it'd be horrible if we had compulsory auto insurance with minimum limits of $25,000. I mean, so many people would be hurt by that. And I guess at the end of the day, you know, what we need is a system where insurers can A, deliver a reasonable product to their insureds, and B, make a reasonable amount of money doing it.
Good. I'll ask John the question first, then Lee, and this is the impact these reforms are likely to have on those who like to defraud the system. Do you believe they'll have any impact? And if so, what kind of impact?
That's I'm always shocked if someone comes into my office and they've been with a paralegal. A lot of the time, I can't believe what I see. I mentioned earlier. I mean, the paralegals got them going to this doctor, this physio, this clinic. It's not real. to the extent that they can only do that for up to $3,500 may impact them. I think you're going to have to do a bit of work to get above that $3,500. If you look at the whiplash-associated disorder there, which, and I mean, a lot of money's been made up till now on sort of sore necks and backs. I forget exactly what the wording is, but it's positive findings on neurological examination. Well, that's one of them. Well, that's not muscle spasm. That's something you can see on CT or MRI or a nerve conduction study. Or the other thing you have to have with a whiplash-associated disorder is a fracture. I mean, it might take the necks and backs out of the game. It might the K factor that we don't know about, or the pre-existing, and as Lee says, the psychological. So I don't know.
Yeah. Lee.
He'll be a pessimist. He'll say no.
Well, actually, there's some of the reforms that we're seeing, and I want to restate there's some good stuff in the package, and some of that is going to help with fraud. I mean, when you take away the target of a higher amount of money, you're going to reduce fraud. When you take away the tools that are used by some of these people, such as unlimited and expensive assessments, you're going to reduce that. So I think that those things will be of some assistance on the margins, but I don't think that's the main thrust of these reforms, and I don't expect to see a lot of change in behaviors.
Okay, I'm going to ask a couple of blue sky questions of the two of you, following which we'll open the floor to questions. So while these two questions are being posed, if you could think about questions to ask our panelists, our debaters, we can move on. So here's the blue sky question, the first one. And I'll ask John first. The question is, what should be the goals of an auto insurance system?
Deliver a fair product at a reasonable price, of course. And then take the examples of those fellows with the anterior cruciate ligament tears or torn rotator cuffs. Let's say they're caught by the minor injury. Let's say they've got a viable tort case. So for me, that's the acid, one of the acid tests of whether the system is working and is reasonable. I am going to call a tort insurer and say, my guy's caught by the $3,500 minor injury cap. He can't work. He needs voc retraining. He's got no money. Will you make this guy some advances? Let's say I ask him for a first advance of $25,000. I will account to you, tort insurer, for every dime of that this way. Here's a sample spreadsheet I intend to use. I will give you the date of the expense. I will put the expense in. I'll put the provider, what it was, and I will attach the receipt. This money will not go towards beer and pizza. I will keep the $25,000. I will parcel it out only after I send you a spreadsheet with attached receipts and your approval. A lot of insurers I know will do that. I see, for example, I see some Chubb people out in the crowd and others in a heartbeat. I know they would. For those that might be reluctant to do so, some might be against advances. The tool I have, I'm going to say, look, here was my guy's situation. He wanted to do the voc rehab, couldn't work. I will hope at a jury trial I could show those efforts and maybe get a jury angry and a little bit enraged that didn't happen, and it might impact on damages.
Lee.
I think it's fascinating that John is suggesting converting a feature of the tort system to become a no-fault system and pay bills as they come in with receipts. And that was what we were trying to do when we brought in no-fault systems in the past. But I think his point is well taken, that the tort system theoretically can fill some of those roles if it's necessary. I think, I'm going to come back to the old refrain, I think the goals of the auto insurance system should be to serve the interests of your customers. And what are those interests? What will they get? What will they feel is fairly priced? Do that, and importantly, align your interests with those customers. In what we've got now, we're fighting with the customers. Every time we have a claim, we're into confrontation, friction, and spending a lot of money at the same time. This should not be the goal of the system.
On that front, from my point of view, tort is a lot less adversarial and a lot less confrontational than ABs most of the time. And in tort, the defense lawyer's not dealing with his customer. I mean, he's dealing with someone else that chances are is with a different company. I'm not. Well, here's the debate. I'm not sure I agree with that. So that's the one. the one place where we disagree. But it's tort is slow. I mean, it's slow. It's inefficient. But you don't have sometimes the adversity that you do in ABs.
Well, maybe my next question will give you a chance to deal with that. And this is where I give you a blank sheet of paper, both you, Lee, and John. And I ask you, design an auto insurance system for Ontario. What's it going to look like? We'll start with you, John.
If it has to be well, I'm optimistic about this system. If it has to be revamped, I would say something like minimum limits in tort of $2 million, and if ABs are what's hurting the system, reduce ABs some way. And and as I said earlier, I think you can penalize a tort insurer for being irresponsible at a trial, judge alone or jury trial, if proper advances aren't made where someone can't afford med rehab and that kind of thing on their own.
Lee.
This is something that I've had to think about a lot. And I think first of all, I have to say, I just think we're making a huge mistake trying to run both an elaborate and contentious no-fault system with an elaborate and contentious tort system. This is not smart on our part. So I think we need to break away from that. So if you start with that premise, okay, we could go to what's mostly a no-fault model, doesn't have much tort in it, and extensive benefits, et cetera, et cetera. That's the Bill 164 model. We had that. It's absolutely not practical unless you have government willingness to transfer a lot of decision-making empowerment to the insurance industry. No evidence of that. At the other end of the spectrum, the Colorado solution. Colorado went through this in 2003 or something like that. And, of course, they had a legislature full of lawyers. But what they did is they got rid of the no-fault system and they brought back a tort system. And last I heard, the people there were pretty happy with it and the insurers there were pretty happy with it. I don't have a great optimism that we can turn back the clock in Ontario, go back to what used to be on tort. A lot of things have changed, contingency fees, the way we approach litigation, what insurers have done with respect to their approaches to litigation, lawyer advertising, all of this kind of stuff. So I'm nervous about that, but that's an option. And the third option that you got to think about is, we're in Montreal, the Quebec option. Is that something that is attractive to the insurance industry? And, I can see why it wouldn't be. You're basically losing a huge chunk of revenue off to the government, but it's revenue with, a 94% loss ratio. So maybe that's not such a bad thing to give over to the government in a sense of public service. So those are the three models that I sort of see that are out there, but I wouldn't say that we're confined to those models. I wouldn't put it past us to be able to devise a model that has some features that we like out of the tort side and has some features we like about being close to our customers and so forth, without getting into this business of being cradle-to-grave healthcare providers with no control. So I haven't got the answer for you in 25 words or less, but I've got the answer for you in where we don't want to be, and that's where we were.
Maybe that's a good topic for an upcoming NICC session.
Right.
Who knows? Anyway, any questions from the audience? Yes. Is there a microphone? 1 second, so we'll bring a microphone, please.
You mentioned the Quebec system, and maybe you could expand a little bit on that, and maybe John and Randy could come in too, in terms of the suitability of the approach in Quebec, how it might apply to Ontario. It seems to me the government is in control of the healthcare system, and we're basically talking about looking after injured people. They might as well pick up the whole thing.
Yeah, that is what I'm talking about on the injury side. The problem that you come into when you're dealing with any of these elaborate first-party injury compensation system is the control over who gets what, making the decision-making, and so forth. If you deal with NICC in Quebec, they are going to make decisions about what you're going to get. It's going to be somewhat abrupt, and it's going to be sort of pushed down the pipe to you. And I've had dealings with the people there, and it was very, very clear that their model is, they are taking care of things, they're making the decisions, and it has no sense of the due process and so forth that's involved in Ontario or tort systems or those kinds of things. So yes, it's very much that, and it's like Ontario workers' comp, similarly. It's a similar process. But that's the only way that governments seem to be prepared to impose, fairly blunt controls on the expenditures, is to have that control exercised by some kind of government agency that has accountability back to the public that way. They don't seem willing to give it to insurers. So I do think that that's embraced in what I'm talking about. The question was, what's wrong with Quebec from a consumer standpoint? Well, my limited experience with talking to the people in Quebec about what they were doing, and it's a number of years ago now, led me to believe that the consumers in Quebec aren't getting a lot of recognition for different kinds of syndromes, treatment, and so forth that would be given in other jurisdictions. And so they may be sort of, they may be having their entitlement to treatment and so forth, treated more abruptly than they would like. But the trade-off is cost, of course, and that may be fine for them. Now, they're not getting competitive service. They have all of those private versus public delivery issues. There may be hidden costs involved in the system. There may be political issues that need to be taken care of. But I guess the question for our industry is, if the government won't let us run it with the appropriate tools, then why do we want it? What good is it to us? What good are we doing our customers? We're just alienating these people, and we have other business with them. Let's concentrate on the other business.
Anything to add to that, John?
Doug, the odd time I've looked at the regime, the benefits you get just pale in comparison to what you get in Ontario. So from my point of view, it's a very unfair system when it comes to compensating injured individuals or people involved in fatalities. I mean, it's great to take the premiums in, but you do want a system that's fair, and I just think the benefits under a regime-type system are very unfair. Every time, that's what my experience with it has been. I know there's some regime guys here, but it doesn't compare to in benefits either A, B, or tort to Ontario, which I don't think is a good thing philosophically.
You have a further question over here?
Randy Bushy, Knox Insurance, North Bay. I'd like to pursue the issue of the $2,000 cap for the medical assessment. I'm in a small town in Northern Ontario, and the orthopedic surgeon in our town, who has done a lot of that work, has indicated that there are two options. Either he just will not do it because he can't do it for $2,000, or he will do a scaled-down version of what insurers have been previously obtaining from him. People in our town who are injured have very few options, so I'm interested to hear from John and Lee as to what are the options that insurers have in situations where people are legitimately hurt, where an assessment will be more than $2,000, but they still have to battle the $2,000 cap.
Well, remember that the $2,000 just applies to the insurer side. I mean, well, it does apply to everyone, but a plaintiff's lawyer can top that up where an insurer can't. I think a responsible plaintiff's lawyer is going to top that up. The end result could be this. It could be, let's say you've got two orthopedic assessments, the one done by the insurer, the one done by the plaintiff. If the plaintiff say it costs $4,000 or whatever, let's just say it costs that, and it was more thorough, and you're at a fiscal arbitration or at a trial, or you're someplace where there's a dispute, the plaintiff's lawyer will be able to cross-examine the orthopedic surgeon to the detriment of the insurance company. Well, you would have liked to have done this as part of your assessment. You couldn't do it. Isn't that correct? Yeah. And so on and so forth. So it'll go. So who's ever listening to that, the arbitrator, the judge will say, hey, this orthopedic surgeon for the plaintiff had a much better opportunity to do a detailed and comprehensive assessment. So I'm gonna go with that orthopedic surgeon's opinion rather than the insurer's. Is how I think it will play out.
Lee.
I know there was some discussion about this $2,000 cap and ways that things might be organized to allow insurers to try to maintain the continuing practice in some way. I don't think they're going to be able to do it for a large percentage of their assessments, which means that they are going to end up in the situation that John talks about, that their evidence is not going to be given equal weight in any kind of dispute. It's not going to be as substantial. It's not going to be as informative to the file handlers. And so the system is not going to be in balance, and this is going to be most prominent on the most difficult cases. You know, your orthopedic surgeon, if he's seeing somebody with a broken leg, the insurance company may not feel they need a lot of assessment about a broken leg. They know what it is. But on other cases, maybe a chronic pain case or a head injury case or something of that nature, a lot more subtlety to it, the insurer is going to be a lot less well-informed.
As part and parcel of that, too, I mean, I, as a plaintiff's lawyer, I can take the $2,000 out of the med rehab. I could, if I want to, towards the plaintiff's orthopedic surgeon's assessment. I'm not so sure I'm going to. I'm not. Say you're dealing with $50,000. I mean, before I did something like that, I would have to talk to to my client and say, look, here's you've got $30,000 left. It's I'm going to take $2,000 out for this assessment. I'm not sure I want to have those conversations. I'm not. I might just say, you keep the $50. It's all for your treatment. I'll do the assessments one way or the other. At the end of the day, I will get the 100% of that cost of that assessment back from some insurance company somewhere.
Any further questions from the floor? Yes, I see one there.
Thanks, Randy.
Carol.
We've talked about the design of Quebec because we happen to be here today. But there's a couple of other provinces in our country that did not go down the Bill 59 route and still embrace the institutions that are here today. Those being Alberta, Nova Scotia, New Brunswick, Prince Edward Island, and Newfoundland. And when we look at their design and we look at the Nova Scotia Minor Injury Guideline and we look at the Alberta Minor Injury Guideline, both of which have been upheld by the Supreme Court of Canada, I was interested in the panel's ideas of, if we're going to go backward in time, have we assessed or looked at those models for Ontario?
Well, I'll respond first on that. The Alberta and the Maritimes don't have the history of having an established infrastructure of assessment providers, treatment providers, paralegal, tow truck drivers, all this, octopus out there with their fingers in the till on 8 tentacles, okay? So that's the problem that they didn't have. Plus, as I understand Alberta, I've looked at these systems somewhat, but I don't practice in those provinces, but the Alberta system, they seem to have good support from the healthcare regulators to keep a lid on abuses, which seems to be the opposite of what we have here in Ontario. They also may have a better economic environment where people want to go back to work rather than get lower benefits, and their benefits are a lot lower than here. So there's a lot of things that are quite different in those jurisdictions than, I said here, I should say in Ontario. So I don't see it directly analogous. I do think it's very, very important that we look at those things to see what lessons can be learned from those experiences, because those are more than pilot projects. There's a lot of experience there, so we should definitely be looking at that. But I'm not convinced that it's the same problem as Ontario.
John?
I've got nothing to add to that. I don't know the systems well at all. So.
Okay, thank you. Are there any further questions? Yes, Joel.
Is there any benefit out of HCI in this environment?
Yeah. HCI 1, that didn't last very long, showed us that there were 26,000 people registered to be health providers. There's only 60,000 claims a year. I mean, what does that tell you about the system? So, I mean, that piece of information, I think, was, that was an education for us, and that's an education for government about what they've got us administering here. So if and that's a little pearl that came out of the registration process. Who knows what else will come out in the fullness of time. I think HCI is sort of the Hubble telescope of auto insurance compensation.
Like that.
We should keep watching us.
I agree.
There you go.
I agree.
Another question here. Jim?
I'd be interested in your thoughts, particularly Lee, on where did this $2,000 cap come from? My understanding is the industry did not want it. The IBC, it wasn't part of their recommendation.
Well, I don't know. I can only surmise that people became extremely concerned about the high cost of assessments. I mean, it was just unbelievable. And people in this room have told me about going to investigate clinics and finding out they did no treatment. They just did assessments because that was more profitable. And I think that, that's, following the money again. It was easier to get the money out of the system that way. So somebody said, okay, we've got to put a stop to this. And it sounds to me like somebody took some reference point. I don't know if it's WCB or pre-1990 Ontario Auto or whatever it is, and found some kind of benchmark and extrapolated it out to come up with a number. You have to understand, a $2,000 assessment, we're seeing assessments that are $20,000 and $30,000. And so it's not like we're shaving off the top 10%. We're basically saying we cannot have that assessment. And this is happening with certain parts of it. I don't think we're going to have too much trouble getting quite a few assessments for our $2,000. It's just, we start getting into the issue of catastrophic impairment, which should be a fairly frequently encountered issue in this new system. We're going to be limited.
John?
Jim, I wasn't at any of those meetings. Some guys in my office were. I know there's some FISCO people in the room. They might have been. I mean, who knows where it came from? I mean, it's a ridiculous number. I mean, it's a ridiculous, obscenely low number. I don't know how that can last. I don't. I mean, there's so many some people can do assessments for 2,000. A lot can't in assessments that are needed and would give insight and into the case.
We have time for one more question. I see it back there. Yes.
I find it also interesting that we talk about Ontario Auto and the Ontario Auto design being broken when in fact it's a GTA issue. And I know that from colleagues of mine in other organizations, they are not seeing similar experiences in the rest of the province as they are in GTA and the kind of that Southern Ontario GTA issue. And neither of you have commented on that in your comments, so would you care to make an observation?
Well, I think that just speaks to the infrastructure role, that those existing cottage industries are located in the GTA, and that's where they have their advertising and their relationships with tow truck drivers and body shops and clinics and paralegals, and all of that web is GTA and a few other places, and that's the proof in the pudding.
And I hear that, and I accept it as the case. I travel 5 kilometers to work. I don't go more than 20 kilometers per hour, so I don't know how it happens in the GTA. I did have a close call. I did have a close call one time. I'm insured with Dominion, and I know George Cook, and taxi driver just missed me by that much, and so I got to work. I called George and said, "Look, George, I just saved you $40,000 by good driving," but I know it is a GTA problem, and I don't know what the solution is. I don't. I mean, as Lee says, there's a very sophisticated system with tow truck drivers and healthcare providers that may not exist outside the GTA.
Lee and John, one last question, a yes-no. Tough one for lawyers to do, but it'll be a yes-no question. Will the reforms have the intended effect? Yes or no? Lee?
No.
John?
I can't answer in one word. I love it. I love the sound of my own voice. No. I'm an optimist, yes.
Thank you very much. So time will tell. Yeah. Thank you very much.
Thank you. Randy, thank you very much.
Oh, well.
Thanks to our 3 panelists and our moderator and 2 panelists. And again, we extend on your behalf a donation to WIC. We have your certificates here, so rather than another type of gift, we've made a donation on your behalf to Women in Insurance Cancer Cure. I've got those certificates for you. Thank you very much for an enlightening panel. Other than a nagging sense that I'm probably paying too much in auto insurance, I found it pretty fascinating. We're going to ask you now to clear the room because this is where we will have lunch with our amazing keynote guest, General Rick Hillier. But in the meantime, they've got to prepare lunch here. So if you can be back here for 12:45, please, that's when lunch will be served.